I suddenly fell ill. I had to request them to reschedule. So thank you very much for accommodating. And good afternoon, everyone. The topic we are discussing today is the corporate restructuring under IBC. So primarily dealing with Section 230 of the Companies Act 2013, which talks about mergers, amalgamations, and the interplay with IBC. So what I propose to do is I have a few the relevant portions of the sections which are there, which talk about from the CRP regulations or from the liquidation regulations. So we'll discuss those. And then I have about 40 case laws because this is more of a case law based topic. This is no, the law as such is very less which is given in the IBC. So I have about a compilation of about 40 cases. We can discuss whatever we are able to finish in the 3 hours. Otherwise, whatever is left out, I'll definitely be circulating the note on the case law compilation, and Madam will circulate it to everybody. So let's see how much we are able to complete in this time. If anybody wants to add their own experiences, if somebody has actually dealt with any of these cases, then please feel free to jump in at any time. So we can discuss it for everybody's benefit. Like I personally, in whichever cases I have handled, till date, I have not handled a 230 matter, like a scheme matter under IBC. So scheme matters, obviously we deal with differently under Companies Act, but not under IBC. So if anybody has actually practically handled that, then we would love to hear your experiences also in that. Right. So let's start. What Section 230 deals with, Section 230 of the Companies Act 2013. It deals with compromises, arrangements, and amalgamation. That is what we generally understand as mergers and amalgamations under the Companies Act. So companies which are companies will go and propose schemes. I'm sure everybody is aware of how the process works in the NCLT, where the scheme is drafted and the scheme is.
Ma'am, can you make the PPT to full mode? It is appearing as two.
Is it?
Yeah.
Okay.
Notes mode as well as the other one.
Okay. Okay. This is better. This is giving a slide show view, I believe.
Yeah. Now okay.
Yeah. Thank you. Yeah, so as I was mentioning, we know how the process works for when we submit a scheme to the NCLT. In general parlance, I'm saying, not under IBC, but where we file the scheme, we get the board approval, then we file the scheme, we file the application, then seek directions for holding various meetings of shareholders, creditors, and unsecured, secured creditors, and so on, which will be allowed. Then we hold those meetings. After those meetings are held, then we go to the second step, which is the filing of petition for approval of the scheme. In the meantime, we will give notices to all the, say, the income tax department, GST department, RBI, or whichever other authorities may be there, the regional director's office, the ROC's office, and so on. And then we await the report when the scheme is being considered by the NCLT, and basis the hearings, the NCLT will pass the order sanctioning the scheme. Then the scheme will be effective basis whatever date we have stated in the scheme. And accordingly, the process will come to an end. Depending upon which NCLT we are in, probably the time limit or time which is taken to complete this process may vary. Again, there could be fast track schemes, fast track processes where we don't approach the NCLT, say if it's a merger of two small companies or mergers of, say, holding subsidiary and so on. So where we have us the option of going for a fast track merger, where we don't go to the NCLT, but we go to only the regional director's office and we follow a similar process there, and we get the scheme sanction. But when we are discussing about these things in relation with IBC, primarily IBC, as we know, is meant for restructuring, for insolvency resolution. So corporate restructuring can also be a way of insolvency resolution, where under Section 230 schemes can be filed, where the corporate debtor, which is the under the IBC, that can have a plan or through a resolution plan, can have a proposal to merge with any other company, or any other company can be merged with this entity. And this could be either reverse merger or a normal merger, whichever way, depending upon the tax benefits or whatever may be available to the resolution applicant. So that is one way of looking at it through the resolution plan. So under a resolution plan, also a resolution applicant can propose that the companies are going to merge. The corporate debtor will merge with the resolution applicant or any of its entities, and it can be a reverse merger also, where the resolution applicant's company can merge into the corporate debtor. So the corporate debtor will be the resultant entity, and that business will be carried on. So that is where we can use 230 as a part of the resolution plan. Now, second is where again there's a provision in the code which talks about utilizing section 230 in course of liquidation also. Now, generally in case of liquidations, we understand that the company is going to get wound up at the end of the process. However, at that stage also, if somebody comes up with a scheme of any arrangement with the creditors or anything, that is also allowed. And there are numerous judgments where even after the commencement of liquidation, the NCLTs have allowed the scheme of arrangement between the parties. And at that point in time also, the schemes have been implemented. So,
Madam, is there any time limit after the liquidation order?
yes, sir. Yes, we will discuss the provisions, sir.
Yeah, okay.
Now coming to the legal provisions. References in IBC, references in the CRP regulations, and the references in the liquidation regulations. So there are different points where the references have been made. First, we will start with the references in the IBC. So in the code, basically, in the definition section in section 5, subsection 26, which defines the term resolution plan. Now, resolution plan means a plan proposed by the resolution applicant for the insolvency resolution of a CD as a going concern in accordance with part 2. Now, we are very well conversant with this definition. We focus our attention on the explanation. So where this explanation was added in 2019. So till that time also, this, when they say that this is for removal of doubts, it means that before this also, a scheme under the resolution plan was definitely allowed. Now they have simply clarified it. So what the explanation says is, for the removal of doubts, it is hereby clarified that a resolution plan may include provisions for the restructuring of the CD, including by way of merger, amalgamation, and demerger. So explicitly, they have added this with effect from 16th August 2019. But before this also, there are judgments which say that, yes, this through a resolution plan and through the course of liquidation, this scheme of amalgamation can be implemented or can be approved in this process. So this is the first reference in IBC. Then we come to the CRP regulations. So this regulation 39BA was added in September 2022. So which talks about when we are either approving a resolution plan at the end of the process, or if the COC is considering whether to put the company into liquidation. At that time, these certain regulations are there, this 39ABC and so on, which we need to consider and which we need to include in the agenda for that meeting, the meeting which is approving the resolution plan. The idea being that in case the resolution plan is not approved by the NCLT, then the committee would have already decided the matters regarding the appointment of liquidator, the fees of the liquidator, whether the company should, in the course of liquidation, whether it should go on as a continue as a going concern, sold as a going concern, how should the assets be sold, and so on. So even though there's a resolution plan which is being approved, all these points also need to be considered, and all these things will be included in the minutes, discussed by the committee and included in the minutes of the meeting. So 39BA is one such regulation which needs to be considered at that stage. So what 39BA says is the assessment of compromise or arrangement. So here they're making it mandatory in a way that the COC should give a thought to whether this is possible. So let's see what 39BA says. While deciding to liquidate the CD under section 33, the committee shall examine whether to explore compromise or arrangement as referred to in regulation 2B1 of the liquidation regulations. Now 2B1 is where the detailed discussion is there regarding compromise and arrangement. But whenever the COC is considering whether it should be liquidated or the resolution plan is being approved, then 39BA says that the COC necessarily must give a thought to the point whether the CD can be, or whether there is any possibility of any compromise or arrangement which can be done, and that we will have to record in the minutes accordingly. The resolution professional shall submit the committee's recommendation to the NCLT while filing application under section 33. So specifically, when you are filing that application, we need to say that the COC has considered this point and whether it agrees to go for a compromise or to explore the compromise or not, that also we will have to specifically state. And also that should be included in the minutes which we will be attaching to the application. So where the recommendation has been made, so where the COC decides that yes, we need to explore the compromise or arrangement option, the RP and the committee shall keep exploring the possibility of compromise or arrangement during the period the application to liquidate the CD is pending before the NCLT. So naturally, there's always a time gap. It could be in months also. From the date when the application is filed to the NCLT for liquidation of the corporate debt till actually the application is heard and till the application is finally decided. So what this 39BA is saying is that even during that time, the RP and the committee shall keep on exploring the options of whether any scheme is possible, whether any party is coming up with a scheme and so on. So during this period, it is mandated. Provided that the provided that the COC has passed a resolution saying that they want to explore the compromise or arrangement. If they don't make that recommendation, then this sub-regulation 2 may not be applicable. Now, that was about 39BA. Now 39C, assessment of sale as a going concern. In a way, both of these may go together. Although when I was trying to look at the case laws on sale as a going concern are completely on a different line. And the case laws under section 230 are different. There are very few which are overlapping. But assessment of sale as a going concern again is one of the other requirements which the COC needs to do at the time of deciding to liquidate the CD or while approving a resolution plan. That the committee needs to recommend that the liquidator should first explore the sale of the CD as a going concern under Regulation 32 or sale of the business of the CD as a going concern. And accordingly, that resolution will be passed. If the committee recommends the sale as a going concern, then the group of assets and liabilities, which according to the COC's commercial wisdom ought to be sold as a going concern, will again be identified separately. And those which can be sold separately will again be identified accordingly. Then this recommendation of the committee will again be placed before the NCLT when the application is being filed either under Section 30 or under Section 33. Now coming to Regulation 39D, again 39D of the CRP regulations. Like I mentioned, we also need to consider this in case the company does go into liquidation. The resolution plan is not approved, even while approving a resolution plan by the COC. This resolution again needs to be considered that in case this ED goes into liquidation, who will be the liquidator and what should be the fees of the liquidator. So the committee beforehand itself needs to pass that resolution. While fixing that fee, which will be payable to the liquidator, there are certain points which we need to be considered by the COC. So the first being that in case a compromise or arrangement recommendation is being made, then whatever period is going to be lapsed in that compromise or arrangement in that period, the fees for that period may be different. And in case in case there is a recommendation for sale as a going concern, then the fee for that period may be different. And the fee for the balance period of the liquidation may be different. So it is up to the COC and the discussions between the RP and the COC about what are the kind of fees that they want to recommend for each of different stage. Now again, we know about the Regulation 4D, which is there, which talks about different options. So in case they say that they're going to go by that table, which is given in Regulation 4, then it's a different thing. But otherwise, this resolutions can be specifically passed by the COC saying for different periods, different kind of fees may apply for the liquidator. Yeah. Now references to the liquidation regulations. So till now we were discussing the CRP regulations. Now the references is in the liquidation regulations. And just last week where the new amendments came in from 12th of February, there is an amendment to this regulation from 12th of February. So Regulation 2B, which I mentioned, which talks about the compromise or arrangement as such, only one regulation which talks in detail about this. So whether compromise or arrangement is proposed under Section 30 of the Companies Act, it shall be completed within 90 days of the order of liquidation. So, sir, to answer your question, the time period is stipulated as 90 days. And again, that recommendation should be there by the COC under Regulation 39BA. So that time period will be counted from the date of order of liquidation. Although there are certain judgments which say that in case there is a possibility of the scheme being implemented or scheme being considered, then there are a lot of cases where the NCLT has extended this time period of 90 days. But statutorily, if we look at Regulation 2B, the time period is given as 90 days.
Okay, thank you.
Sure, sir. Then provided that a person who is not eligible under the code, so again we come back to the 29A eligibility. In case that person is not eligible under 29A to submit a resolution plan, he shall not, such a person cannot be a party to any such compromise or arrangement. So he is not entitled to file a resolution plan. He is not entitled to submit a scheme of arrangement. So that is also very clearly defined. Now coming to the amendment which came on 12th of February, where they say that provided further that the liquidator shall file up the proposal of compromise or arrangement only in cases where such recommendation has been made by the COC under Regulation 39BA. Now, this was not there earlier. This has just come in last week. So, the Regulation 39BA, which we discussed, now that will have more teeth in that sense that in case the COC did not recommend a proposal of compromise or arrangement, then probably the liquidator may not at all be able to consider such a compromise scheme if it comes during the liquidation process. Although I'm sure that, as time passes, if there's a good scheme which is there and instead of selling the company as assets of the company, if a scheme is going to be there, I am sure that there could be judgments in the future which say that, yes, this, even though there is no recommendation, probably the liquidator or the SCC, because SCC is an extension of the COC in any case. So the SCC may consider it during the course of liquidation, but we'll have to wait and see that. Provided further that the liquidator shall not file such a proposal after expiry of 30 days from the liquidation commencement date. So whatever proposal of compromise or arrangement, now here they are talking about that process shall be completed within 90 days. So sub-regulation 1 talks about the entire 230 process needs to be completed within 90 days from the date of order. Now this new proviso which has come in talks about that the proposal for such compromise or arrangement, since the COC has already recommended it, then within 30 days of the expiry of the liquidation order, the liquidator should file such scheme with the NCLT so that the 90 days timeline may also be met. So now it is for us as liquidators that where we are being appointed in case the COC has made such a recommendation that the compromise or arrangement needs to be considered, then we need to be actively on the lookout and actively drafting the scheme and so on, so that as soon as the liquidation order is passed, within 30 days, we need to file the scheme before the NCLT. So that is something which will be an added timeline for us here. Now, 2B continues further. Provided further that where the recommendation to explore proposal of compromise or arrangement has been made by the committee, yeah, sorry, I think this is a repetition. Shall file the proposal within 30 days, yes. Then the time taken on compromise or arrangement not exceeding 90 days shall not be included in the liquidation period. So now we know the liquidation period we need to finish within 12 months and so on. So these 90 days which are taken for this particular process of considering this scheme, they will be excluded from the liquidation period. And in case that fails, then the liquidation period will be counted from such date. So in case, some cases we might have to file an exclusion application later on. Now, any cost incurred by the liquidator in relation to compromise or arrangement shall be borne by the CD, where such compromise or arrangement is sanctioned by the tribunal under subsection 230. Section 230, subsection 6. So if the liquidator incurs any costs in the compromise or arrangement, that will be borne by the CD. Now, borne by the CD again means that through this process, it will form part of the liquidation cost. And provided that such cost shall be borne by the parties who propose the compromise, where such compromise or arrangement is not sanctioned by the tribunal. If the tribunal does not allow the scheme, then whatever cost has been borne for this entire process will be borne by the parties themselves. Otherwise, it will be the CD's cost, and that will form part of the liquidation cost. Now, Regulation 4, which talks about the liquidator's fees. So we know the cases covered in sub-regulation 1, that is as per the table, depending upon what is the period of sale of assets and what is the quantum of the sale and how much is the amount is distributed. Basis that the sub-regulation 1 talks about the table. of how much percentage of fees is to be paid to the liquidator. In case that doesn't, that is not being contemplated by the COC and something different has been decided by the COC, then in sub-regulation 2 says that in cases other than those covered under sub-regulation 1, the liquidator shall be entitled to a fee at the same rate as the RP was entitled to during the CIRP for the period of compromise or arrangement under section 230. Now, if the COC has passed a resolution giving a different fee, then that will have precedence over this. But if the COC has not decided the fee for this for the period when the compromise or arrangement is to be considered, then for that period, the liquidator is entitled to get the same fee as what the resolution professional was getting during the CRP process. So in case of ambiguity, this clause can be used. Then there's a regulation 45A also, which talks about preservation of records. So in that, it gives a list of all the records which need to be preserved. In that, one of the records is all the related correspondence, related documentation for any invitation, consideration, and approval of plans, proposal, or any schemes which may be received in case of going concern sale in the liquidation process or in a compromise or arrangement under 230. So whatever schemes may be received, whatever proposals are received, whatever correspondence happens in that regard, that we need to preserve the record as a liquidator for the stipulated time under 45 days. Then again, if we see the model timelines for the liquidation process that talk about the exclusion of these 90 days. So the timelines in the regulation 47 say that these 90 days will be excluded and other timelines will accordingly be adjusted after that 3 months after that 90 days. So this was about the this was about the references in the regulations. Now we can turn to the case laws. So these are about, as I mentioned, 39 to 40 cases of different NCLTs, NCLATs, and a couple of them of the Supreme Court, which have thrown light on the process. Some of them have given in elaborate how the process needs to be followed for the case of compromise and arrangement. And also, some of the NCLAT judgments where certain decisions have been given where the scheme could not have been passed. Now, considering whether the CDs and MSME, then its interplay with section 29A and so on. So all those cases are have tried to include whatever I could find. So let's discuss. So the first one is a Supreme Court case, so which is Meghal Holmes versus Srinivas Girni Samiti. So this is a very celebrated case, and it has been referred to in a lot of cases afterwards, which have been passed by the NCLAT and so on. So this case has been referred time and again. Now this is an old case and which talks about section 391 of the Companies Act, so which was the old section for section 230. So this is a case under under the Companies Act 1956 and passed under section 391. So what however, whatever has been said, the ratio which has come out of this particular case law is applicable under 230 also, that has been applied in a number of cases. Under IBC, where the scheme is proposed in this in the course of liquidation. So in Meghal Holmes, the Supreme Court says that the argument that 391 would not apply to a company which has already been ordered to be wound up. So we can draw a parallel here with a case under IBC where the liquidation has already commenced. Cannot be accepted in view of the language of 391(1) of the Act, which speaks of a company which is being wound up. If we substitute the definition in section 390A of the Act, this would mean a company liable to be wound up and which is being wound up. It also does not appear to be necessary to restrict the scope of that provision, considering the purpose for which it is enacted, namely the revival of the company, including a company that is liable to be wound up or is being wound up. And normally the attempt must be to ensure that rather than dissolving a company, it is allowed to revive. So the same logic or same things what we say in case of IBC liquidation also. that the attempt should be to revive the company to the extent possible, even though it may be in the course of liquidation. So something similar has been stated in Megal Holmes case by the Supreme Court, and this is now, this case law is now very widely used. Second one is Arun Kumar Jagatramka, member of Gujarat Coke.
Madam, please increase the size to fit into that.
Okay. Okay. Better?
Yeah, it's legible now.
Yeah.
It's
The
better.
second, yeah, thanks. So the second case is of Gujarat NRE Coke. Now this is a NCLT judgment which later on went in appeal also. So we'll look at both the cases. So in this case, in Gujarat NRE Coke Limited, the company went into liquidation under the code. In the liquidation order, the liquidator was directed to first dispose the company as a on a going concern basis within 3 months of the liquidation commencement date. And if that does not happen during this period, then the process of sale under liquidation was to be followed. This was what was directed in the liquidation order. So first sell the entire company as a going concern. If that doesn't happen, then sell the assets in pieces. Now the promoter of the company filed an application under section 232 of the Companies Act for obtaining sanction regarding the scheme of compromise and arrangement between the petitioner and the secured unsecured creditors, the foreign convertible currency bond holders, and the shareholders of the series. So it was a comprehensive scheme which was proposed. The adjudicating authority, that is the NCLT, allowed the application under the aforesaid sections, and the appointed liquidator was appointed as the chairperson for calling these meetings. So the NCLT allowed the application to convene the meetings to consider the scheme, and the liquidator was appointed as the chairperson for all of these meetings of each of these stakeholders. And directions were also issued for the issue of notices to various government departments and so on, as what happens in a regular scheme matter before the bench. Now this order went in appeal.
The case under Companies Act, not under IBC.
Under IBC, it's under IBC only. So this was under liquidation, sir. Now this case is under liquidation.
This one is only under a Companies Act.
No, under IBC. So the company went into, that was the first one.
Okay.
This was the first one, the Megal Holmes, the Supreme Court judgment.
Okay.
This was under 391 of the Companies Act 1956, which is being referred to now in all the cases. Now I went on to the second case, which is under IBC. And in the course of liquidation, a scheme was proposed by the promoters of the company. The scheme was proposed with the shareholders, with the unsecured and the secured creditors, and the foreign convertible bond holders. For convening those meetings, the NCLT allowed that scheme to the extent of convening the meetings. So that application was allowed, and the liquidator was appointed as a chairperson for all of these meetings. As we know, in a normal merger matter, the directions come for holding the meetings, who will be the chairperson, and 30 days notice and so on. So all those directions were given by the NCLT in the first instance here. So this is the first case which is under IBC, but which considers section 230, a scheme under section 230. Now we go to this went into appeal. So in the appeal, what happened was the previous scheme, which was filed by the promoters, that did not go through, and the liquidation process continued thereafter. Then some of the representatives of the employees of the company, they filed another application before the NCLT, and they proposed another scheme of arrangement. So the first one was proposed by the promoters, that did not go through. The second scheme has now come in the course of liquidation, that is being proposed by the representatives of the employees of the company. And here they are saying that this scheme is being proposed by the shareholders along with one entity called as TEV study. Now the TEV study was going to infuse the funds in this company and so on, and that was the scheme, and they were going to pay off the creditors accordingly. But this scheme was rejected by the secured creditors. So in the meetings, the scheme did not get through. The secured creditors did not vote in favor of the scheme. And accordingly, the NCLT also did not pass the scheme because the secured creditors had not passed the scheme. So now against this order of the NCLT not passing the scheme, the appeal was filed by these representatives of the employees. So this is the second time over what is happening. Now this appeal is being considered by the NCLAT, and in which the directions what the employees have sought is that consider the scheme with further consequential relief, whatever was asked in the appeal and in the original application before the NCLT. On the ground that TEV study has not been considered and the NCLT Kolkata bench has not taken into consideration the proposition of law that the liquidation is the last resort and all efforts have to be made to revive the company. So now the employees have gone to the NCLAT seeking the revival of the scheme or the acceptance of the scheme. Now, what has been held by NCLAT? NCLAT has held that admittedly 90 days a time limit from the date of the order of liquidation has elapsed. So this was much later because there were 2 rounds of the scheme also. Now, after lapse of more than 2 years, the NCLT has declined to reconsider the scheme on the same grounds as were taken earlier for approval of the scheme. The revised scheme placed by the shareholders before the creditors has been rejected. It is noticed from the impugned order that the creditors have objected to the addition of TEV study. So that other entity which was there, the creditors have objected to their inclusion. It goes without saying that the scheme of compromise sought to be reconsidered on the basis of TEV study could not be forced upon the stakeholders who were unwilling to consider that even at in the first instance. So there was no point in actually going with the same scheme or a similar scheme again with the inclusion of TEV study. Thus, no change in circumstances warranting reconsideration at the hands of the NCLT is made out, and accordingly, the appeal was dismissed here. So the employee's application to consider that scheme failed ultimately. Now the next one, this is also again the 4th case which is there, Amit Gupta and others. This has also been referred in number of other cases, and whatever has been discussed in this case has been again utilized in a number of other cases afterwards by the NCLT as well as by the NCLAT. Now this is again an NCLAT decision of under IBC, but a scheme being proposed under Section 230 of the Companies Act. So these title in the short synopsis is that before taking steps to sell the assets of the CD, the liquidator should take steps in terms of Section 230 of the Companies Act. Now again, mind you, these are all our old cases, 2018, 19 and so on, where this regulation 2B, that addition is not there, which has now come in, which says that unless the COC recommends such a sale, then we as liquidators or we as RPs, we cannot proceed with considering that. But then again, we will have to see that all these are previous cases. Now these appeals, we are before the NCLAT, so the appeals are against the orders passed by the NCLT. The appeals have been preferred by the management of Hindustan Door Oliver Limited, which was the CD, and HDO Technologies Limited, which was the other corporate debtor. So there were 2 companies which are being considered here. Against the orders of such and such date, and where the NCLT Mumbai has passed orders of liquidation under 33(1) for both of these companies with certain directions to the liquidator. Now the counsel appearing on behalf of the appellants, that is the management, has submitted that the liquidator is supposed to keep the companies as a going concern even during the period of liquidation. If so necessary, the liquidator can also take steps under Section 230 after consultation with the members or creditors of the company for making arrangement with third parties. So what the appellants are saying is that necessarily the liquidator should keep it as a going concern. Like no, the words used are for the beneficial liquidation of the corporate debtor and so on. So the words in Section 35 speak about the beneficial liquidation of the corporate debtor. So what their contention is that the liquidator should keep the companies as a going concern even during the period of liquidation. And if necessary, the liquidator can take steps under Section 230 after consultation with the members and so on. And obviously with the approval of the NCLT. It is also submitted that it is open to the liquidator to sell the companies to third parties before selling the movable or immovable assets of the company separately. So like we were discussing, first consider whether it can be sold as a whole, as a going concern. If not, then sell the individual assets. Now, NCLAT has held that in view of the provisions of Section 230 and the decision of the Supreme Court in Megal Homes, the first one which we discussed, NCLAT has directed the liquidator to proceed in accordance with law. He should verify the claims of the creditors, take the custody and control of all the assets, properties, and so on. Carry on the business of the corporate debtor for its beneficial liquidation as prescribed under Section 35. And the liquidator will access information under Section 33, consolidate the claims under 38, and after verification, either admit or reject the claims under Section 40. But before taking steps to sell the assets of the corporate debtors, the liquidator will take steps in terms of Section 230 to examine whether there is a possibility of any scheme or with any of the creditors or with the members and so on. And the NCLT, if so required, will pass the necessary order. Only on failure of revival will the NCLT and the liquidator proceed with the sale of assets. So this is one more attempt, one more chance given to the CD to try and getting sold as a whole, or being revived, rather than selling off each individual asset in the process, and where obviously the realization is going to be less as compared. And again, the chances of revival of the CD are almost nil in that case. Okay, then next one is also on similar lines. If the members of the CD or the creditors approach the company through the liquidator for compromise or arrangement by making a proposal of payment to all the creditors, the liquidator on behalf of the company will move the application under Section 230. So this is Air Carnival Private Limited, again an NCLAT judgment, where the NCLAT has held that we are of the view that the liquidator should act in terms of the aforesaid directions of the appellate tribunal and take steps under Section 230 of the Companies Act. If the members of the CD or the creditors approach the company through the liquidator for compromise or arrangement by making a proposal of payment to all the creditors, the liquidator on behalf of the company will move that application under Section 230 before the concerned NCLT. In terms of observations made in the Sekaran case, on failure as observed above, steps should be taken for outright sale of the CD so as to enable the employees to continue in service on such outright sale. So if the first option to be explored is the compromise or arrangement, if that doesn't work and if the company is a going concern, next option to be explored is that of sale on a going concern basis. And if that fails, then the next step would be to sell the assets individually. The sixth one is also different case, although, but on very, very similar lines. So here again, the discussion was about whether the resolution applicant who has proposed this scheme and so on, whether he's eligible under 29A or not. So in this case, since the resolution applicant, or rather the scheme, the person who had proposed the scheme was not eligible under 29A, so there was no question of allowing him to submit the scheme. Seventh is the liquidator on behalf of the company can move an application under 230. So the similar points are being discussed in that in all these judgments. Again, another NCLAT judgment. So here again, if the members of the CD or the creditors approach the company through the liquidator for compromise or arrangement by making a proposal of payment to all the creditors, then the liquidator will move that application to the NCLT. Here, the appellants, that is who were the promoters, had challenged both the orders of the NCLT Chennai bench. And the counsel appear on behalf of the appellant had submitted that the CIRP had not proceeded in accordance with law. The RP or the COC had not acted in accordance with the provisions of the code, which resulted in non-approval of the plan. Again, then they are going further and alleging that the appellant cannot be held to be ineligible under 29AG because of various reasons which have been given in the application. And that the NCLT did not decide the issue of the ineligibility of the resolution applicant. So they have moved the NCLAT now. Now what has been held here? Again, on similar lines that just 1 second. Yeah, so what has been held by the NCLAT here is that since the resolution applicant is not, the promoters are not eligible under 29A, then the question of all these other discussion does not arise. And the scheme which has been proposed by them cannot be considered. Now the next one, whether the NCLT will have, does have the power to play dual role. One as the adjudicating authority for liquidation and other as a tribunal for passing order under Section 230. Now this question was again discussed. So we know that in both the cases, so NCLT is playing a dual role. NCLT is also going to consider the liquidation application and the liquidation process of the CD, as well as in case any scheme is proposed during the process. That scheme will also have to be passed by the NCLT in the capacity of being a tribunal under Section 230, as mentioned in 230. So the question here was whether NCLT can play both these rules. So the NCLAT has held this NCLAT judgment is a lot in detail. It talks about what all steps should be taken by the liquidator and so on in the course of liquidation. So just a summary is given here. It's an interesting judgment. So in the CRP against this Serva Lakshmi papers, in the absence of any approved resolution plan, and since the 270 days were completed, the NCLT Chennai bench passed the order for liquidation. Another appeal has been preferred by RCEL, and apart from being the financial creditor, it had also filed a resolution plan. The other respondents who are there had filed another resolution plan. So there was a lot of cross applications and a lot of litigation would have entailed here. However, the committee of creditors, having not found any of them viable and feasible, have not voted in favor of any of the resolution plans with majority, and because of which the liquidation order has been passed. So in spite of there being 2 or 3 resolution plans, the COC did not vote in favor of any of them, and accordingly the CD has gone into liquidation. Now, what were the questions before the NCLAT and what were the findings of NCLAT? The first question, what was discussed there was what are the steps which should be taken by the liquidator during the course of liquidation. So for us as RPs, what is relevant is what is the discussion here. So during the liquidation process, following steps are required to be taken for the revival and continuance of the CD by protecting the CD from the management and from the death by liquidation. So the first step is again, the first paramount importance is that there should be attempts made to revive the company and to continue the CD as a going concern, protect it from the erstwhile management, and also protect it from being sold as each and individual asset in the course of liquidation. So this can be done either by way of compromise or arrangement with the creditors under Section 230, or if not, by way of sale of the business of the CD as a going concern or by sale of the CD as a going concern. The last stage will be the death of the corporate debtor by liquidation, which should be avoided in all circumstances. So this is the detailed discussion which is there as regards the steps what the liquidator should take. Now, the next question which was discussed here was that this process may not be completed within 90 days. So what about that? So normally the total period of liquidation is to be completed preferably within 2 years. At that time it was 2 years. Now it was reduced after 2019 to 1 year. Therefore, in the Amit Gupta case, which we discussed previously, the appellate tribunal allowed 90 days time to take steps under Section 230 of the Companies Act. In case for any reason the liquidation process under 230 takes more time, the NCLT may extend the period if there is a chance of approval for arrangement of the scheme. So that 90 days time is not sacrosanct. NCLT does have the discretion to extend that period as and when required, depending upon the merits of the case. Now, the third question which is discussed is whether the NCLT does have the power to play that dual role. One as the adjudicating authority to consider liquidation matters, and other as a tribunal for passing order under Section 230. So the discussion what has been made in this order is that during the proceeding under Section 230, if any objection is raised, it is open for the NCLT, which has the power to pass an order under 230 to overrule the objections if the arrangement and scheme is beneficial for the revival of the CD. While passing such order, the NCLT is required to play a dual role, one as the adjudicating authority for liquidation and another as the tribunal for passing the orders under Section 230. As the liquidation is taken up under the code, the arrangement of scheme must be in consonance with the statement and object of the code. So now they are trying to balance both of them and show the interplay between Section 230 of the Companies Act and the provisions and the powers of the NCLT and the IBC. Statement of object of the code, the scheme should be in consonance with the statement of the object of code, meaning thereby that the scheme must ensure maximization of assets of the CD and balance the stakeholders such as the financial creditors, the operational creditors, secured creditors and unsecured creditors without any discrimination. Before approval of the arrangement of the scheme, the NCLT should follow the same principle and should allow the liquidator to constitute a committee of creditors for its opinion to find out whether the arrangement of the scheme is viable, feasible, and having appropriate financial metrics. It shall be open to the adjudicating authority as a tribunal to approve the arrangement or scheme in spite of any objections which may be raised by any creditor or any member, keeping in view the larger interest under the IBC, which is the maximization of the assets of the CD. Okay, the next case is JM Financial Assets, again NCLAT Delhi case. It is open to the company through a liquidator to make arrangement even with a class of creditors like financial creditors, or to accept one or other resolution plan for the purpose of making arrangement and framing scheme after following the procedure laid down in section 230 of the Companies Act. So here they're talking about the scheme either in the course of liquidation or in the course of the CRP by way of a resolution plan. Now, the facts of this case, the CRP was initiated against one Forward Shoes Private Limited. Pursuant to the resolution process, one A-Star Properties became the successful resolution applicant. Then respondent number 4, who is some Siddharth Credit and Investment, was also to make some financial contribution in support of respondent number 3, that is a resolution applicant. The plan submitted by them was approved by the NCLT, Chennai, in March 2018. After approval of the CD, after approval of the plan, the CD was taken over by respondent number 3, who was the resolution applicant. But later on, it failed to pay the due in terms with the resolution plan. So the resolution plan was not implemented properly. Accordingly, as we know, in case the resolution plan is not implemented, then the company goes into liquidation. So in this background, JM Financial Asset, who was a financial creditor, filed an application before the NCLT, who by on order dated December 18 ordered for the liquidation of the corporate debtor. So since the resolution plan was not implemented, the financial creditor filed application for liquidation, which was directed by the NCLT in December 2018. Now, the appeal has been filed by the erstwhile promoter and managing director of the CD against this liquidation order. Now, the counsel appearing on behalf of the appellant submits that instead of passing the order of liquidation, NCLT should have taken more steps for revival of the CD by accepting some other plan. So, one plan has already failed. What they are proposing is that can you please mute, sir? Thank you.
तो मैंने रिटर्न किया वो कॉन्ट्राडिक्शन थी એટલે પછી મેં તમને કોલ લગાવ્યો
Okay.
તમારો આવે છે ને નામ માર્કિંગ છે તરીકે આવે છે
ત્યાં ચાલુ છે ને
Sir, can you please mute
બે
yourself?
એક જ જોઈન્ટ કર્યું છે
Mr. Patel.
બેવ મારામાં ચાલે છે
અચ્છા
હા નહીં તો એવું હોય તો
Yeah, so here the application, the appeal has been filed by the promoters of the company against the liquidation order, saying that the NCLT should have accepted one more plan or given chance for one more plan, and because the ultimate aim of the code is to revive the CD. In view of, so here what the NCLT has said that such submission cannot be accepted. In view of the specific provision made under the insolvency code, we are of the view that the NCLT had no option but to pass the order of liquidation and could not have resorted to revival of the CD by taking fresh resolution plans, because we know that once a plan is approved and if there's a failure in implementation, the automatic consequence is liquidation. So the NCLT is also saying that the NCLT did not have any other option but to pass the order of liquidation directly. Then the next question in this was to what steps should the liquidator take in the order of liquidation has been passed, which has already been dealt with. We discussed that in detail. What all steps was have been suggested by the NCLAT for any liquidator to take, like first going for a scheme, then going for a going concern sale, and then going for a sale by of each of the individual assets. So that those steps have already been elaborated in this particular case. So here again they are reiterating that and saying that it is open to the company through the liquidator to make arrangement with even a class of creditors like the financial creditors, or to accept one or other resolution plan for the purpose of making arrangement and framing scheme after following the procedure under 230. So in the course of liquidation also, if that scheme does come up through the liquidator, the courts can consider that. So the 10th one. If the High Court passes order on the judicial side, NCLT will act as per the order of the Honorable High Court as may be passed. So this is again NCLAT Delhi judgment. This appeal has been filed by the appellant, who was a ex-chairman and shareholder of Amardyk Chem Limited, which was a CD, which was in liquidation. And he was aggrieved by the order of 2018, where the NCLT had dismissed some CP, which was filed by the appellant for approval of the scheme of compromise or arrangement propounded by him between the company and its creditors under the old act, under 391, 394 of Companies Act 1956. The petition was dismissed on the ground of locus standi without going into the material facts of the case. And accordingly, his contention is that the NCLT misinterpreted the law. Now here there's a little difference in the situation because this case is, this company was earlier under BIFR. And from BIFR, where the matter was pending before the High Court, from there it was transferred to the NCLT and so on. So a lot of events have taken place. Briefly stated, the facts are that the company was incorporated way back in 1954. And the company was referred to the BIFR as being a sick company in 1993. After following the procedure prescribed there, the BIFR referred the company to winding up before the Bombay High Court in 98, and the High Court admitted the winding up petition in 1998. The High Court order was passed in 98, and it also mentioned that the BIFR has recorded an opinion that it was just and equitable that the company should be wound up. And the High Court also recorded that he had perused the various orders of BIFR and he had found that the rehabilitation and revival of the company is not possible. And therefore, in public interest, the company should be wound up. Now, all this has been recorded in the Bombay High Court orders. Accordingly, the order was passed to wind up the company, and the official liquidator attached to the High Court was directed to take charge of all the affairs, assets, and properties of the company with the usual powers under the Companies Act. So the company is already now being put into winding up in 1998. There have been notings to the effect that there is no possibility of revival of this company, and accordingly, the winding up has started. Now, after all these orders were passed and the winding up procedure has started, in 2008, there's a High Court order which shows that the High Court has considered inventory report of the valuer of the assets of the CD, which are still available at the site. Then the High Court gave certain directions to the official liquidator regarding the sale of those assets, those movable assets which were there on site. The High Court gave directions to the official liquidator for sale of those assets, and for that purpose to issue advertisements in the newspapers for the purpose of that auction sale or whatever sale was going to take place. Now, the appellant, who is the promoter of that company, he has raised some issues which have been discussed, which are against that sale order. So, sale order which was passed by the High Court. This appellant has raised certain issues with respect to that sale. And he then stated that he had proposed to the High Court that the appellant, along with some other co-investors, was in a position to revive the company. So basically, he had a scheme of arrangement with the creditors, which was ready, and he had some investors who would invest in the company, and they would try to revive the company. Now, the appellant is relying on these observations, which have been made by the Bombay High Court in the order passed for sale of the assets. And he has now claimed that he has the locus standi to submit a scheme of compromise or arrangement under Section 391 before the Bombay High Court. And he did submit that scheme also. So he moved the first motion application. So we know in the first stage, when we move the company application, the first application was moved for convening various meetings of various stakeholders like the shareholders, creditors, and so on. So that was allowed also by the Bombay High Court in 2010. So it has reached this stage that the convening of the meetings has been ordered by the Bombay High Court, and for a company which is already into liquidation before it, and with the official liquidator. Now, it is also argued that at this stage, the respondent official liquidator has never objected to the right of the appellant to file such a scheme of compromise under 391. So till now, till even the first motion application was filed and allowed by the Bombay High Court, the official liquidator never raised any objections, and the meetings were convened and so on. Then the appellant is also claiming that when he went to file the second motion petition, so for approval of the scheme before the Bombay High Court, when that petition was pending in 2012, from 2012 to 2016 it was pending. That is when the Minister of Corporate Affairs issued that notification transferring all the pending matters all the scheme matters from the High Courts to the NCLT. So accordingly, this matter also, which was for the second motion petition, this got transferred from the Bombay High Court to the Mumbai NCLT. So now he has approached the NCLT for approving that scheme. but it appears from the facts that the scheme was not allowed by the NCLT Mumbai bench, and against which this appeal has been filed. So now here what the NCLAT further observes is that the appellant had filed the proceedings before the Honorable Bombay High Court, but it appears to have got transferred to NCLT by that office letter of internal letter, which may be of 2017. It does not appear that there was any judicial order to transfer the case from the Bombay High Court to the NCLT. The appellant cannot be held responsible for this transfer. However, now when the issue appears to be going to the root of the jurisdiction, although we propose to remand back the matter to the NCLT, it appears to us that the present proceedings in NCLT should remain stayed, giving opportunity to the appellant to move the Bombay High Court to ensure that the scheme filed in the liquidation or the liquidation proceeding before the High Court should be before the same forum. Because the liquidation is also pending before the Bombay High Court, the scheme should also be remanded back to the Bombay High Court. That was the view which was being considered by the NCLT. We have no doubt that a scheme of compromise and arrangement can be filed even when the liquidation proceeding is pending. But if such application is filed, it would be a proceeding relating to the winding up, and accordingly the same has to be before the same forum. So finally the order which was passed was, they set aside the order of the Mumbai NCLT and restored the transfer petition before the bench, and it was directed that the NCLT should give one more opportunity to the appellant to move the Bombay High Court in that scheme matter. The next one again on lines where what are the steps being required to be taken by the liquidator for continuing the corporate debtor and to protect the corporate debtor assets and so on. So that is the next case, again NCLAT judgment. So where they are discussing that during the proceeding under section 230, if any objection is raised, it is open to the NCLT, which has the power to pass the order under section 230 to overrule the objections or whatever the points may be considered in the scheme, that the NCLT has the powers to discuss that or to consider those. Then the 12th, Concept Management Consulting versus Anand Chandra and others, another NCLAT judgment. In this case, the appeal has been filed against the orders which are filed in, which were passed by the Kolkata NCLT in 2019, January. By this order, again, the adjudicating authority had had passed the order for liquidation, and one Mr. Rathi was appointed as the liquidator with certain directions about the steps to be taken in the liquidation process. Now, the financial creditor who was there, he filed his claim before the resolution professional, but the claim was not admitted. And the allegations have been made against the erstwhile IRP on the ground that it did not follow the procedure, and because of which this company has now gone into liquidation. Now, what has been held by NCLAT after considering the objections is that the liquidator is required to act in terms of the opposite directions of the NCLAT and take steps under 230. So again, the directions are to the effect that first, the option of the scheme and the sale as going concern to be considered for the beneficial liquidation of the CD. If not, then the individual assets may be sold in the course of liquidation. If the members of the CD or the creditors or the class of creditors approach the company through the liquidator for compromise or arrangement by making a proposal of payment to all the creditors, then the liquidator can consider that scheme, and on behalf of these of the company, he will move that application under section 230 to the NCLT. So similar kind of observations, what we have discussed till now. Again, if that doesn't happen, then the steps for the outright sale of the CD as a whole, as a going concern to be taken, and if not, then sell the individual assets. The next one is another NCLAT Delhi judgment, DR Balakrishna Raja versus Indian Bank. Now, in this case, the appellant, who was the promoter of the CD, that is BKR Hotels, preferred this appeal, challenging the order of May 2019, passed by NCLT Chennai, whereby the order of liquidation had been passed under section 33 and the liquidator was appointed. So the similar facts where the company could have been saved from liquidation, but still the liquidation order was passed and so on. And what are the steps to be taken in this regard? So again, the NCLAT did not interfere with the order of the liquidation and directed the liquidator again to consider a scheme if it does come under Section 230 from any of the parties, otherwise to proceed with the liquidation. Fourteenth, if the liquidation order is passed by the NCLT, the promoter can take advantage of Section 230 of the Companies Act 2013 in consultation with the liquidator. Again, another NCLAT judgment. So where again 29A also comes into play. If the promoter was eligible to file a resolution plan under 29A, then he can take advantage of 230 and come out with a scheme under the resolution under the liquidation process also. So in this case, Anil Bafna, who was a promoter and director of Jain Granites, that is the CD, he preferred this appeal against the order of the NCLT passing the order of liquidation in the absence of viable and feasible plan. So here again, the NCLAT has held that in case there is a scheme, the promoter can take benefit of the 230 in the course of liquidation and file a scheme, and whatever the steps have been elaborated to be taken by the liquidator there. Next one again, NCLAT judgment, where then it has been held that NCLAT cannot extend CRP period beyond 270 days, except for the purpose of Section 230. So in this case, one of the resolution applicants has filed the appeal against the order of the NCLT, whereby the NCLT has directed the liquidation of the corporate debtor. Now, what was discussed in this that 270 days were very few days were remaining for completion of 270 days. Until that time, there was no resolution plan which was considered or which was more than the liquidation value. Accordingly, the original plan and the revised plan which were submitted by the RP to the COC have not been considered, and they have been rejected by the COC, and 270 days have already passed. Now, on that basis, the CRP has completed and the liquidation order was passed. Again, in case there are any objections, this appellant said that he wanted to file the plan and which was not considered. So again, on similar lines, NCLAT has held that the liquidator is required to act in terms of the directions of considering any scheme in case that scheme is proposed by the promoters or any other person, and that scheme will be considered within that time limit. If not, then the sale as a going concern, and if not, again, a sale of the individual assets. Again, the 16th one is also more or less on similar lines. Again, it was for rejection of the resolution plan and for not trying to revive the company, where again, the promoter, if he is eligible under 29A, then he can again file a scheme under this and under Section 230, and in the course of liquidation also, the company may be revived by utilizing that scheme. And the next one is where it is discussed that if the resolution plans are not accepted in the CRP, then the liquidator has an option to accept its resolution plan as schemes or arrangement in the liquidation process. So even if the plan may not go through as a plan, it may come by way of a scheme in the liquidation process, and that scheme may be considered by the liquidator. State Bank of India, another NCLAT judgment. So Section 10 application was filed and the CRP was initiated for Tirupur Surya Textiles Private Limited. The NCLT after that also ordered for liquidation. Now the promoter, shareholder of both the CDs, they have challenged the liquidation orders alleging non-compliance with procedural requirements of the CRP. Again, on the grounds that no resolution plan was received and there was enough efforts were not made for revival of the CD. Now again, the Section 230 has been discussed, where again the NCLAT has discussed that even in case no plans were received here, during the course of the liquidation, the scheme may come from the promoters if eligible, they may themselves file a scheme and that scheme may be considered by the liquidator by bringing it to the NCLT. The 19th one is Bharti Defense NCLT Mumbai bench, where the 90 days have elapsed and the liquidator is seeking further extension after 90 days for submission of the scheme before the Mumbai NCLT. So here, which was since this case involved the extension of the scheme submission period and a stay on the recovery proceedings during the liquidation, NCLT authorized or approved the extension, and on the basis that there's a need for financial commitment and there's a need for trying to revive the company as a going concern. Otherwise, auctioning of the assets would fetch much lesser value and there would be no chance for revival of the company. So accordingly, the NCLT has allowed the extension beyond 90 days. So now this, the 20th one, Mahesh Kumar versus Neelam Singh, that is also unclad judgment, which is again an appeal before the NCLAT, where the appellant has challenged the admission of Neelam Singh's application for insolvency against Mega Software Industries. Now, the appellant has argued that the allottees of flats should not be considered as financial creditors, and he has also claimed a number of frauds and other things in the agreements, while also considering challenging the liquidation decision. Now, here again, the appellate tribunal has discussed that the appellant, which is facing liquidation, intends to settle the matter through an arrangement of or a scheme under Section 230, and the liquidation order was passed. Still, within the liquidation period also, the courts can consider the scheme, the liquidator can consider the scheme if it is received in the stipulated period. Now the next one is one Adinath Enterprises case, which has similar facts. Again, here the liquidation order has been challenged, arguing that the RP failed to take necessary actions, such as issuing the expression of interest and so on for the resolution plan. So here again, on that basis, they have sought an exclusion of 162 days from the CIRP process. Now, the company has gone into liquidation, which has been challenged. So here again, the NCLT has held that the resolution professional's failure is, it cannot be the resolution professional's failure that there was no resolution plan, which was received during the period, which was not received during the period. So accordingly, the RP cannot be held responsible in that sense. And in case there is any scheme which can come in during the course of the liquidation, that scheme may be considered basis the provisions and within the stipulated timelines. Kshitij Gupta, again, here the question was whether that 90 days can be extended. Yes, so the answer is that yes, the 90 days period can be extended. Okay. The 23rd one. Promoter shareholder, in view of Section 29A of the IBC, cannot file any application for compromise or arrangement in terms of Section 230 to 32 of the Act to take over the company. Again, point which we have already discussed, if the promoter is not eligible under 29A to submit a resolution plan, he cannot submit a scheme also. Next one, IE Trading Company, again, unclad decision, which talks about even during the liquidation stage, recourse can be had to provisions of 230, subject to the timelines. So in this case, the COC in the meeting had recommended the liquidation of the corporate debtor with 100% voting share. The decision was based on factors such as absence of business operations for more than 5 years, no operating revenue, and so on. So it was not basically a going concern. The NCLT accepted the RP's application for sending the corporate debtor into liquidation and passed the liquidation order. Now, the appellant has claimed that he was eligible to submit the arrangement or compromise scheme under Section 230, and he did not get that opportunity during the course of the CRP process, and the company ought not to have been put into liquidation without giving him an opportunity. Now, what was held in the appeal is that the appellant's eligibility to submit the compromise proposal was there even during the liquidation stage if he was eligible to submit the plan during the course of CRP. Accordingly, the scheme may be filed during the course of liquidation also. I think we discussed this case already. Yeah, this is IVRCL, another NCLAT judgment. Again on similar lines. So here the appeal is filed by the First Global Finance Private Limited against rejection of its resolution plan. So First Global was a resolution applicant. The plan was rejected by the Committee of Creditors of IVRCL, and the rejection was based on deviations in expression of interest and non-fulfillment of eligibility criteria. Now, the IVRCL, which was in insolvency, which was initiated by State Bank of India, the RP issued invitations for EOI and data extended deadline. 2 rounds of EOI were conducted, and the appellant, that is the First Global Finance, submitted the resolution plan as a part of consortium. However, COC rejected the resolution plan, citing deviations, non-submission of EMD and so on, and non-compliance with the eligibility criteria. So, despite multiple submissions and revisions, the resolution plan was not accepted by the COC. Now, the appellant is seeking a direction from the appellate tribunal to compel the respondent to file an application under Section 230 to record a scheme of arrangement. Now, 230 deals with compromises or arrangement, and the appellant aimed to utilize Section 230 proceedings to present an alternative arrangement outside the CRP, which the COC rejected. So, apart from the resolution plan, he also submitted a scheme, which was rejected by the COC. Now, the decision of the NCLT. The NCLT upheld the COC's rejection of the resolution plan, stating that the non-compliance with EOI and those other conditions were there, even there was a failure to submit the EMD. The authority emphasized that the primary focus of IBC is the revival and continuation of the CD, and the appellant failed to meet the necessary criteria which were fixed by the COC. The Swiss ribbon judgment is also discussed in detail in this particular judgment. Now, the appeal which was filed by the appellant was also dismissed by the NCLAT, and the NCLT's decision for the liquidation of the CD was continued. Now, the 27th case. If the corporate debtor is an MSME, even if the promoters or directors have been declared as willful defaulters, they can apply under the provisions of 230 of the Companies Act, as they are exempted under 29A of IBC. So, the benefit of 240A, if it is available to the CD, then even though there may be willful defaulters, and if they're falling under the exemption of C and H of 29A, then the promoters themselves can again file the scheme. Yeah, the next one is a liquidation order after approval of the resolution plan. So again, similar lines, how the company was put into liquidation was challenged everywhere. And the NCLT has held that in case the appellant had any grievance, he may come up with a scheme. Here again, the resolution plan was approved by a majority of 88%. And the resolution plan was approved in 2019. And then the resolution professional and so on, and the resolution plan was implemented after that. Since some of the portion was not implemented, then the corporate debtor was put into liquidation for non-implementation of the resolution plan. So that decision was challenged before the NCLT, the decision of the NCLT to put the company into liquidation was challenged before the NCLAT, and where the NCLAT has noted that time is of essence, that is speed is of essence in the court, since it's a time-bound process and everything needs to be completed within the given time frame. So the time is of the essence, and timely resolution of insolvency is always preferred rather than having a timely resolution should be the aim here. But timely liquidation is preferred over an endless resolution process. So they cannot drag the CIRP process endlessly. With regard to the compromise or arrangement, they have said that the NCLT has the powers to deal with Section 230 and either under a scheme during the course of liquidation or the scheme during the course of resolution by way of a resolution plan. Whatever decisions are need to be taken regarding the approval of the scheme, the NCLT already has the authority or the powers to take those decisions. So accordingly, NCLT is vested with all those powers to consider the scheme as well as to consider the liquidation or the resolution of the process of the CD. So ultimately, what was held that there was no wrongdoing in the terms of the NCLT putting the company into liquidation, and time was of essence there. They also directed that whatever EMD or other things they may have been paid by the by the appellant, that should be repaid. Okay, again, similar things, whether decision to take the allegations are that the COC's decision to liquidate the corporate data is vindictive and mala fide. And if enough efforts have not been made for revival of the CD. So again, the discussion is that the a scheme can come during the course of liquidation and the company can be revived. Yeah, this is something which discusses some other different point. Again, Asis Logistics and NCLAT Delhi judgment, which talks about the notification. Before the notification, whether the status of the CD changes with regard to its MSME status, then what is the position of the resolution applicant and whether those promoters would be eligible to file the scheme of arrangement under Section 230. So in this case, the NCLT had held that the promoters are not eligible to submit the scheme, even though their position had changed after the classification notification of MSME in June 2020 came in. After that, even though they qualified to be an MSME, they cannot. And accordingly, the NCLT had rejected the scheme or had rejected the proposal of the promoters, saying that they are not eligible since the CD cannot be termed as an MSME. However, this was appealed, and the NCLAT held that since the definition of MSME has now changed by virtue of that notification, now the promoters will be able to submit, because if the CD can be considered to be MSME. So the promoters will be eligible to submit a scheme of arrangement to the liquidator, and the liquidator can consider that during the course of liquidation. Yeah, so this judgment is again about the how the scheme of arrangement actually is being proposed. So in this, they have given the details, they have discussed the details of the scheme and so on, who is the resultant company and so on, and what is the role of each of these people. So in this case, this application is filed by the liquidator under the IBC, under Section 230 of the Companies Act, read with IBC, in the course of liquidation. So the scheme has come in the course of liquidation. The application has been filed in respect of composite scheme of arrangement, by virtue of which this Florent Choose Private Limited, who is the transferee company or the corporate debtor who is in liquidation. So that Choose Private Limited is the corporate debtor. Uppers Private Limited, hereinafter referred as the transferor company. One is another Nivedhana promoters, who are the resulting company, and one individual investor is there. And that scheme is between all of these people and their respective creditors, shareholders and creditors. So now, in addition to the company in liquidation, that is respondent number 1, there are 3 other entities who are considered, and it's a composite scheme covering all of these people. Now that scheme has been submitted to the liquidator, and the liquidator has filed that scheme for approval before the NCLT. So the liquidation started in February 2019. In March 2019, basis the COC resolution passed in February 2019, and the liquidator was appointed to act as such. And the applicant has filed this application under 31(1)(a) when he constituted a stakeholders consultation committee. Then the liquidator received that composite scheme of arrangement from all these parties, and that scheme provided for a scheme of arrangement between the company, the secured creditors, the unsecured creditors, the statutory authorities, and the employees. So all virtually all the stakeholders were considered were being covered in that particular scheme, and which was known as a scheme of arrangement. Now, respondent number 1, which is the CD. Now, that company was a subsidiary of the company in liquidation, and the transferee company, the transferor company, was going to amalgamate and transfer its entire assets with the company in liquidation. So on, for each of the respondents, the role has been given, that how is the scheme designed to cater to all the interest of all the stakeholders. Now, after hearing this application, the NCLT was inclined to issue directions for convening of the meetings of all the stakeholders comprising of the secured creditors, unsecured creditors, and other creditors of the company. And the NCLT has also stated in this order that suitable modifications may be made with respect to the standard directions in case of a scheme matters, with taking into account the facts and circumstances of the case. What the NCLT also directed is that the liquidator of the company shall place the scheme of arrangement before the stakeholders consultation committee of the company, and the meeting of that SCC should be called, and in that meeting that scheme should be placed before the SCC. And further they proceed to give the directions on how that meeting should be convened. So if we see the A, B, C, and so on, they're talking about what is the notice should be given to each of these stakeholders, the length of notice, and so on, how the stakeholders committee, how the representation should be on the stakeholders committee for each of these stakeholders, so that the stakeholders consultation meeting will take care of all of the approvals which are required from these parties. Then it also, so these are very detailed guidelines. So if you read the order will have very minute guidelines about how the meeting should be convened and so on. The liquidator will be acting as the chairman for that meeting, and he will be required to submit his report after the meeting. And also regarding the claims, what would be the amount and what would be each person's stake in the stakeholders consultation committee, and also all those things have been discussed here. Meetings to be convened within 45 days and not exceeding 60 days from this order, how the notices should be sent, how the meeting should be held, and so on. All those detailed directions have been given. Publication of notice, which newspapers it should be given, and so on. So like what we have in a regular scheme matter, all those directions are given in detail in this order. Then what about the voting? How should the voting share be determined? That has also been specified. Then issue of notices to all other departments, income tax department, RD, ROC, and so on. That has also been covered here. After the service of notice, usually we have the chairperson of the meeting who is appointed. He will be filing the affidavit of service and so on. Here the liquidator is required to file that affidavit. So liquidator has been directed to file that affidavit of compliance for service of notice, etc. And after the meeting, within 7 days, the report on the meeting and the outcome of the meeting, that report also needs to be submitted within 7 days by the liquidator. The order also talks about the arrangement for expenses. So who is going to bear the expenses? So here they're saying that the scheme proponent should make arrangement for the expenses to be incurred for these meetings, including the fees of the chairman and so on, and for placing the scheme before the stakeholders consultation committee. And again, they're giving the leeway that in case there is any query which is being addressed by the stakeholders in relation to the scheme, the liquidator may offer the clarifications, and in case the liquidator needs any clarifications, he may move appropriate application before the NCLT for any of the procedural aspects where any guidance may be required. So this is a very, very detailed order about who should do what and so on. So in case anybody needs to actually conduct those meetings and all, so this order can be referred to. Then the next one is again granting of extension beyond the 90 days period to complete the scheme. So here 30 more days have been granted beyond the period of 90 days. Again, the logic being that, the revival or rehabilitation of the company is of paramount importance rather than following the liquidation process and allowing the company to die. Yeah, this is another very detailed judgment of NCLAT. On the Stakeholders Consultation Committee, the role and compromise or arrangement under IBC. So in the matter of Sri Bhavani Paper Mills, NCLAT Delhi case. So in this case, the scheme of compromise and arrangement was filed 1 day before the expiry of 90 days. The scheme of compromise or arrangement by respondent 2 and 3 was filed well before 90 days. So there are two schemes which are there. Respondent number 2 has already intimated the liquidator that they are submitting a scheme for compromise, and further steps pursuant to auction notice of such and such date should not be taken. After submission of the scheme was considered by the SCC on such and such date, and it was not accepted. Hence, the liquidator treated herself absolved from the consideration of any scheme any further, and proceeded with the auction on that date when of the assets of the corporate debtor. So the scheme was to be considered. That scheme, the 90 days, the respondents had communicated to the liquidator that we are submitting a scheme, and the auction was called on 25th of September. However, before that auction could be held, the Stakeholders Consultation Committee meeting was held, and in which the scheme was rejected. Since the scheme was rejected, the liquidator did not wait because there was no scheme to be considered. The scheme has already been rejected. So the liquidator proceeded with conducting the e-auction as proposed. Now that has been challenged by the respondents that without giving them an opportunity, the auction was conducted. So here the NCLT has directed the liquidator to consider the scheme, and also directed that no further steps to be taken with regard to the auction of the assets of the company. Now this was what the NCLT has held and directed the liquidator. Now the role of the Stakeholders Consultation Committee was also discussed in this meeting, in this order. The Stakeholders Consultation Committee is only to advise the liquidator on matters relating to sale under Regulation 32. Regulation 31A9 provides that the advice of the SCC shall be taken by a vote of not less than 66%. And further, Sub-Regulation 10 states that the said advice is not binding on the liquidator. So it is only advisory in nature. The action of the liquidator in placing the scheme of compromise or arrangement before the SCC was uncalled for and is not in accordance with the provisions of the code and the regulations. Section 230 of the Companies Act, read with Regulation 2B of liquidation regulations, indicates that it is the liquidator who is to take a decision as to whether the scheme for compromise is to be placed before the tribunal by an application or not. When sub-regulation 1 of the Regulation 31 specifically refers to the advice of SCC on the matters relating to sale under 32, SCC was not any competent forum for obtaining any advice with regard to the scheme for compromise or arrangement submitted under 230. So the point in question is why did the liquidator place the scheme before the SCC? According to this order, it was the liquidator's duty to place that scheme directly before the NCLT and not before the Stakeholders Consultation Committee. Now, the NCLT also discusses the applicability of Section 230 subsection 6 in case of where no meeting was convened under 230 subsection 1. Now, entire 230, the scheme of arrangement is considered under entire Section 230. So, 230 subsection 6 refers to a meeting held in pursuance of subsection 1, that is in pursuance of meeting directed by the tribunal on an application filed by the liquidator. In the present case, no meeting was convened under 231 because the application did not go before the NCLT at all. So hence there is no applicability of Section 230 subsection 6. Reliance on Section 230 subsection 6 was wholly out of place and was uncalled for. The above holding that the scheme of compromise or arrangement submitted by respondent 2 and 3 has not been approved by the creditors during the SCC meeting, referring to section 230 to subsection 6, indicates misconception of the whole statutory procedure by the liquidator. Further, we have already noticed that the subregulation 9 of 31A, the advice of SCC is to be taken by a vote of not less than 66%. So again, what they are reiterating is that the liquidators ought not to have placed that matter for voting before the COC, before the SCC. The liquidator individually should have brought that scheme before the NCLT directly. Now, the computation of 66% voting and all, that is about these percentage of voting and how they are going to vote in the SCC. Now, on all of this, the NCLAT, what did the NCLAT finally hold? NCLAT holds that section 230 subsection 2 clause C uses the expression any scheme of corporate debt restructuring consented to by not less than 75% of the secured creditors in value. Subclause C of 232 is attracted when there is a scheme of corporate debt restructuring. The expression used in subclause C is corporate debt restructuring. Debt restructuring is a very well-known concept. Debt given by a lender can be restructured by the lender by any scheme issued by the lender or the RBI or by the central government. Debt restructuring scheme which are issued by the RBI or central government from time to time are to mitigate the hardship of the borrowers. So they are drawing a distinction here between the two type of schemes. When lenders restructure the debt, that is permit the borrower to make the payment in different time schedule or different installments as per any scheme, the said debt will be a debt restructuring. And we accept the submission of the counsel for the appellant that the scheme proposed by respondent number 2 and 3 is an arrangement by the respondents, wherein alternations have been proposed in terms of the loan and lesser amount would have been proposed to be paid for settling of the claim, which is restructuring of a corporate debt. Hence, the scheme under section 230 submitted by respondent 2 and 3 ought to have consent of not less than 75% of the secured creditors, and an affidavit to that effect ought to be accompanied with the scheme. Obligation to obtain the consent of 75% of the creditors is on the person who proposes the scheme. When the scheme was submitted by respondent 2 and 3 to the liquidator was required to intimate the respondent 2 and 3 to obtain consent by 75% of the creditors. And respondent 2 and 3 were to present the scheme before the creditors and impress them to give their consent. Now, comments on the process to be followed by the liquidator for obtaining approval for compromise or arrangement. So, in the present case, the liquidator, after holding respondent 2 and 3 to be eligible to submit the scheme on 21st October, placed the scheme before the stakeholder consultation committee on the next day, that is 22nd October, and refused respondent 2 and 3 to present and clarify the scheme before the SCC. So, this is what the liquidator has actually done in this case. The liquidator first put the agenda, which was for consideration of the scheme submitted by R2 and 3. And when it was disapproved, the liquidator submitted another proposal before the committee as to whether R2 and 3 be permitted to present their scheme before the stakeholder consultation committee, which obviously got rejected since the scheme has already been disapproved by the committee prior to this item being taken for consideration. It was incumbent upon the liquidator to first put the resolution before the committee as to whether R2 and 3 be permitted to present and clarify the scheme, which was not done to the prejudice of respondent number 2 and 3. The persons who submitted the scheme, that is R2 and 3, could not get any opportunity to present the scheme before the financial creditors and to obtain their consent. The liquidator, after declaring R2 and 3 eligible on the 21st October, got the scheme disapproved on the next day in the meeting of 22nd October without giving any opportunity to respondent 2 and 3 to appear before the consultation committee or to approach the financial creditors for getting their consent to the scheme. Prior to submission of the scheme, the respondent 2 and 3 had no opportunity to approach the financial creditors for their consent, since the liquidator had declared 2 and 3 as ineligible to submit the scheme under 29A. So before that also, they could not go and negotiate with the financial creditors or meet them or understand the expectations. So now what the discussion happens is the person submitting the scheme under section 230, subsection 1 of the CA 2013, is entitled to place the scheme before the financial creditors and make efforts to obtain their consent, which was denied to respondent 2 and 3 in the present case, due to the course adopted by the liquidator, which was as noted above. We thus are of the view that the respondent 2 and 3 are entitled to an opportunity to place and explain the revised scheme before the financial creditors. And it is for the financial creditors to consider the scheme for purposes of giving consent as contemplated under section 230. The counsel for the appellant has submitted that the scheme submitted after the order of the NCLT proposes a higher amount as compared to the one which was offered by the appellant in the auction in October 21. So now the final decision which has been given by the NCLAT is, from the above discussion, it is clear that the meeting of the SCC and its minutes is not in accordance with the statutory scheme, nor it can be held that the SCC had given any advice to reject the scheme. Consequently, the liquidator's decision to reject the scheme submitted by R2 and 3 based on such advice also falls on ground. Hence, we conclude that there was neither any consideration of the scheme nor there any valid reason for rejecting the scheme by the liquidator, and consequential action after rejection of the scheme to proceed with the auction is also unsustainable, since the decision to proceed with the auction was consequent to the rejection of the scheme submitted by R2 and 3. And again, that scheme was also which was held to be contrary to the statutory scheme of the code of regulation 2B. In view of the foregoing, the appeal was disposed in the following manner. R2 and 3 were allowed 1 month's time from this date to submit the revised scheme along with an affidavit indicating the consent of financial creditors as contemplated by section 230. In the event R2 and 3 are able to obtain the requisite consent of the financial creditors, such scheme submitted before the liquidator shall be filed before the NCLT for taking further proceedings under 230. The NCLT may finally decide other applications which were also there in this case. And accordingly, the matter will be placed before the NCLT for further consideration. So in short, what they're saying is that it is the responsibility of the person proposing the scheme to obtain the consent of the financial creditors, and along with that consent, the respondents or the scheme proponent should come to the liquidator with the approved scheme from the financial creditors with a 75% majority. And then the liquidator, if that is in order, the liquidator is then bound to file an application before the NCLT for the NCLT to consider the scheme of amalgamation or whatever the scheme of arrangement which may be filed. The next one is also the NCLAT Delhi judgment. Appeal is filed against the Kolkata, with the order of the Kolkata bench. Appellant is a suspended director of the corporate debtor and has filed his appeal challenging the order of the adjudicating authority, rejecting the IA filed by the appellant. Here also, the CRP had commenced. There was expression of interest which was received. The prospective list of resolution applicants was also published. Then certain plans were received and plans were approved by 100% votes by the COC. After that, the appellant has filed, after the plan was approved, the appellant has filed this application seeking various reliefs, including a prayer to set aside the entire CRP and to reinstate the board of directors, and praying that for proceedings instituted under section 230 of the Companies Act be revived. So they had already filed some applications under 230. They should be revived and the CRP should be set aside. So the submission raised by the appellant on the basis of the scheme of arrangement under 230 was elaborately considered by the adjudicating authority, and it has been rightly held that the scheme having never been approved by the creditors cannot come to any benefit of the appellant, and further, after initiation of the CRP, the present appellant, who is a suspended director, is hit by section 29A. So his scheme proposed cannot be considered in the course of CRP or in the course of liquidation. The adjudicating authority has a very elaborate and well-considered order, has discussed all the submissions which were raised on behalf of the appellant and has rightly rejected their submission. The order passed by the NCLT is well considered and needs no interference by the NCLAT. Okay, this is another NCLAT judgment in the matter of Manish Jain, ex-director of PK Sales versus the liquidator. Again, the ex-director has filed an application against the liquidator against the order of liquidation which was passed by the NCLT, saying that there was a willful disobedience on the part of the liquidator. So on 8th of January 2020, the bench had passed an order directing the liquidator not to proceed to confirm the sale of assets of the company until the permission is obtained. This particular order was passed on the submissions made by the Learned Counsel for ex-promoters that a scheme under 230-232 should be considered before proceeding towards liquidation. Subsequently, the present application for initiation of contempt proceedings has been filed on the ground that the liquidator has sold away the assets of the company. The point to be noted here is that it is 2 years that the applicant has not proceeded to file any scheme and the petition under 230 of the Companies Act, and has been dragging the matter. As there is no scheme or petition filed by the applicant under Section 230, the action taken by the liquidator with regard to the assets of the company cannot be considered as contempt, because the liquidator has already waited for 2 years and has sold the assets after that. In view of the same, the I is dismissed. So the NCLT dismissed this, the I which was filed by the directors with suspended powers. Now, after that also the NCLT directed the liquidator to proceed with the sale of assets in terms of the Y. Sivaram Prasad, the case which we discussed, which talks about giving first opportunity for a scheme, then an opportunity for sale of assets as a sale of the company as a going concern, and then going for liquidation sale of assets. So all of those things have been reiterated in the order again. Now the NCLAT says that the order has attained finality and the liquidator has proceeded to auction the sale of the asset. It is an admitted fact that the property was sold in 2021 and which was again recorded in the minutes of 2020 in the stakeholders consultation committee. So detailed notings have been made which says that the CD is not a going concern since April 17. The CD is out of business for more than 2.5 years. There is no KMP available in the CD. There are no employees in the CD. Assets against liabilities and claims are not favorable to restart, and the revival of the CD is not possible. However, the representative of the board of directors submitted that once management is handed over to them, they can clear all liabilities and claims of the CD. So, which will be a standard thing which we hear in almost all the cases where they say that they are able to settle the matter and so on. But detailed notings have been made in the minutes, which is helpful for the liquidator also to prove that all these things, if it goes to before the NCLT, that all these things were considered by the stakeholders committee and the COC, and then only the liquidation decision was taken. So I think similar has happened in this case, and the order of the NCLT was not interfered with, and the liquidation was proceeded. This is another case of SNS Diagnostics. The only difference here is that in this case, the scheme was proposed by an independent director of the CD. So that the person who is proposing the scheme was an independent director. And the question was whether this person is debarred under 29A from filing or does he become a related party? That was the question which was discussed in this. So yeah. So the NCLT Delhi bench had passed the order, and that order is now being challenged before the NCLAT, whereby the application filed by the applicant was dismissed on the ground that is disqualified to submit a compromise or arrangement as he is one of the directors of the CD and the applicant being a related person. Now the appellant is an independent director of both the companies, that is the corporate debtor and the applicant, the scheme applicant. The CD was incorporated in such and such and was classified as a non-government company. The process of CRP was initiated. Nobody came forward to submit a resolution plan in pursuance of the information memorandum and expression of interest. As there was no resolution plan received, the company went into liquidation. And in the liquidation process, the appellant submitted a scheme of compromise and arrangement. That this scheme was rejected by the NCLT on the ground that he is a related person and disqualified to submit a scheme of arrangement in view of the bar as per Regulation 2B, read with Section 29. Viewed from any angle, the principle laid down in ArcelorMittal is applicable to the present case since the dispute relates to pre-amendment to Regulation 2B of the liquidation process, and no disqualification be attached to an independent non-executive director as per Regulation 2B to submit the scheme of compromise or arrangement. The appellant being independent non-executive is not disqualified to propose the scheme in the pendency of the proceedings relating to liquidation prior to the commencement of amended proviso to 2B. Both the council fairly requested to set aside the order as impugned order is illegal and contrary to law. In view of the submissions of both the council, the order is liable to be set aside. Hence, we find that the NCLT committed a grave error in dismissing the application based on the principle laid down in Arun Kumar Jagat Ramka, without appreciating the facts therein and the date of amendment of regulation 2B and the facts of present case. As such, the order is liable to be set aside. So the order of the NCLT in which they had not allowed the independent director to submit the scheme was set aside, and he was allowed to submit the scheme. This is another very relevant judgment for us about what happens to the fees of the liquidator in case there's a scheme of arrangement and in case the fees are to be paid in stages. Then what are those stages in which the fees will be paid to the liquidator? So in this case, the CRP was initiated against one Meka Dredging Company Private Limited in February 18. Since there was no resolution plan which was received, the COC passed the resolution for liquidation of the CD. The order of liquidation came sometime in September 2018 and the appellant was appointed as the liquidator. The respondent submitted a scheme of compromise under section 230 in 2019 in light of the judgment of Y. Shivram Prasad. The NCLT passed an order in January 2020 regarding sanctioning the scheme and the eligibility of the respondents under section 29A. Now the liquidator is aggrieved by the order passed by the NCLT. And then the present appeal is filed on the ground that the NCLT held that the fees payable to the liquidator will become payable only upon occurrence of the events of respective receipts and disbursal at specified dates and not otherwise. So we know that table which is there in Regulation 4. The adjudicating authority directed the liquidator to desist from claiming the amounts towards liquidator fees as immediately payable. The liquidator calculated the fees payable to him as a percentage in relation to both realization to the extent of 91 lakhs in the aggregate with a breakup of 70 lakhs towards the fees calculated on the basis of realization, and the balance amount is computed on the basis of amount to be distributed to the stakeholders as a percentage, which is amounting to 21 lakhs. So we know in that Regulation 4, there are two stages. One is when the amount is realized and one is when the amount is actually disbursed. So both there are different percentages for each of the limits. So accordingly, the total fees were coming to 91 lakhs, but which was to be paid at different stages of disbursement. The stand of the respondents is that the compromise scheme as envisaged by the scheme proponents as a scheme of compromise or arrangement, the same cannot be divided into two parts. One is for fixing the percentage of fees of the liquidator upon realization, and the second on the basis of distribution of proceeds to the stakeholders as contemplated under Regulation 4 of the liquidation regulations. Now, what the NCLT has held is the adjudicating authority, having considered all the aspects and observed that the scheme as contemplated by the respondents cannot be considered as a transaction of sale falling within the ambit of Regulation 32. The amended Regulation 4 of the liquidation regulations draws a distinction in this connection in the event of a scheme proposed, and as well as in his absence as repeatedly brought forth in the earlier portion. No such distinction, or for that matter, no specific mention has been made in relation to a scheme and in relation to the fees payable to the liquidator under the concerned regulations pre-amended. So in the pre-amended regulation, there was no distinction between what are the fees which are payable to a liquidator in case of a scheme in case the scheme is approved. So now we have that clarity that the same fees may be paid. That time, the pre-amended regulation, that clarity was not there. So the NCLT has observed that in case of any infraction on the part of the respondents in implementing the scheme as sanctioned, with regard to the liquidator's fees in accordance with the table which is given, that shall be brought to the notice of the adjudicating authority. So in case there is any default on the part of the scheme proponents, then that default should be brought to the notice of the NCLT. The NCLT also clearly stated that upon occurrence of the event of disbursal or a receipt, the payment becomes due to the liquidator on a percentage basis of such actual receipts and disbursal and not otherwise. The NCLT has also directed by the order of so-and-so that the liquidator to become an independent observer of the board, which is a part of the implementation agencies of the scheme. The NCLT observed that the liquidator should not have withheld the handing over of the reins of the company in liquidation and its management even upon approval of the scheme as early as January 2020. It is clearly held that the liquidator, being the implementation agency, which is required to manage the affairs of the company in liquidation, and he is not the liquidator in that capacity. The NCLT clearly observed that the liquidator's fee is not payable immediately as demanded by the liquidator and is required to be excluded from the statement as annexed along with the auditor's certificate. The NCLT further directed the liquidator to make arrangement to hand over the reins of the management to the CD, including the possession of assets of the CD, if not already done, within a period of 10 days from the date of the order. It is also observed that no fees shall be chargeable by the liquidator for the same, and if not handed over as above, the risk and responsibility and costs shall be to the personal account of the liquidator without any recourse to the funds or assets available with that of the CD. So in case he does not comply with the order of the NCLT, any cost or other things which may come, that will have to be borne personally by the liquidator and not out of the assets of the CD. Now against this order, the liquidator has filed an appeal. Now let us see what the NCLT has to say on this. Decision of the appellate tribunal. Our combined reading of Regulation 2A with Regulation 4 of IBBA liquidation regulations shows that the fees of the liquidator can be decided by the COC before a liquidation order is passed by the tribunal under Section 33. And in its absence, Regulation 4 subregulation 3 shall come into play, wherein it is provided that the liquidator shall be entitled to a fee both on the percentage of the amount realized, net of liquidation costs, and of the amount distributed as per the percentages given in the table. The parties are in concord that at the time of passing resolution under 33(2), seeking the liquidator's fee being part of liquidation cost in terms of 516, read with Regulation 2A and 4(2), had not been fixed by the COC. And in the circumstances, Regulation 4(3) comes into play. So there was no resolution of the COC to fix the fees of the liquidator. So they had to go by the schedule or the table given in Regulation 4, sub-regulation 3. Having gone through the order passed by the NCLT of July 2020, this tribunal do not find any infirmity or illegality in the above order. This tribunal takes serious note on the part of the liquidator that the liquidator has failed to obey the orders of the adjudicating authority in toto, and also is evident from the observations in the order itself. Further, the respondents also clearly mentioned that the liquidator purposely delayed in handing over the reins of the CD to the respondents for the reasons best known to him. It was only a partial handing over which was done by the liquidator to the respondents. Keeping in view the paramount interest of the CD, this tribunal directs the liquidator to hand over the books of accounts to the respondents within a period of 1 week from the date of this order, if not already handed over. Viewed in that perspective, the tribunal comes to the conclusion that the liquidator has not made out any case either on law or on facts. Further, this tribunal holds that the appeal is frivolous and vexatious and the same is dismissed, but there is no order to cost. So the conduct of the liquidator in charging those fees or in not handing over the assets of the CD till the time his fees are received, that conduct has been heavily criticized by the NCLT as well as by the NCLT. Now the next one is again an NCLAT judgment. So again on the lines of liquidation, the bringing in the scheme in the course of liquidation and the extent and the rights of the MSME CD to bring in such a scheme. And we now come to the last one with this of Edelweiss Asset Reconstruction versus Synergy Dure. So this is a case where the all the cases which we have discussed till now, where the scheme was brought in the course of liquidation. This is the case where the scheme of arrangement was brought in the course of, by way of a resolution plan. So the CRP was initiated against Synergies Dure, and after submission of the resolution plan, a number of other applications were preferred by the various parties under Section 60 subsection 5 before the NCLT. All the applications have been rejected by different orders passed by the NCLT. And the resolution plan submitted by Synergies Castings as approved by the COC with 91% has been approved by the NCLT also under Section 31(1). an application was filed by the applicant, who is also the appellant, seeking to declare that all the decisions taken in the COC meeting held on such and such date was invalid, and consequently to set aside and questioning of all resolution plans, or all the resolutions passed in the meeting and the process thereafter. The adjudicating authority, after hearing the parties, by another order observed that all the facts relating to the related party considered, so there were some questions about whether a particular party was a related party, and there were some other questions about the transfer, the assignment of debts. So because of which the COC constitution itself was challenged. Now all those applications were set aside, were dismissed, and after that the resolution process continued. In that, there was one application which was also about the approval of resolution plan, which was submitted by Synergies Castings. So now, as regards the resolution plan submitted by Synergies Castings, the NCLT says that it cannot be held to be in violation of Section 30, subsection 2 or any of the provisions of the law on the ground of violation of Section 230, 232. Section 230 of the Companies Act relates to power to compromise or make arrangement with creditors and members, whereas 232 relates to merger and amalgamation of companies. The question of filing an application before the NCLT under 230, 232 does not arise at the stage of filing of the resolution plan, as it is not known as to which of the resolution applicants of resolution plan will be approved. Once a plan is approved, one may argue that in terms of the provisions of Companies Act, a formal order of amalgamation is required. No such argument can be advanced at the time of approval of the resolution plan, which merely proposes the merger. So the question was at what stage that application should be filed before the NCLT. The appellants were contending that the application should be filed before the NCLT along with the resolution plan itself, and order should be obtained. So where the NCLT has held that that is not the case, because we don't know whose resolution plan will be approved. At the most, that can form part of the application which is being filed to the NCLT as a part of the resolution plan. And since since the insolvency code is a code in itself, and Section 232 has overriding powers, so all other procedural requirements need not be dealt with. Everything can come under by way of that merger under the resolution plan itself, and no specific different process or different application is required to get the scheme approved by way of a resolution plan. So in view of that, the resolution plan was upheld, and the appeal was dismissed. Yeah, so these were the summary of the cases of matters under Section 230, Section 232 of the Companies Act, read with IBC. I'll circulate this note to the participants through the ICSI, so that I know when we are reading it here and all, it's not that effective, because we need to read the entire case sometimes to understand all the facts and what all has happened and how the NCLT or the NCLT has arrived at a particular decision. But this was merely a summary. We cannot discuss the entire case laws here in this given time frame. So probably I have given the citations also in that note. You can go back and refer to those citations and read the orders in detail. Apart from this, there is very little as such jurisprudence in the sense of the legal provisions which are contained in the liquidation regulations or which are contained in the CRP regulations. So we have to rely heavily only on these case laws for the procedure to be followed, even if we may be submitting a scheme through a resolution plan, or we may be considering at the liquidation stage. So I think we need to have heavy reliance on the case laws only. And the scheme, the process under the scheme, which is already given in the Companies Act, that process is already there. So whether to go for such a consideration, whether to go for a scheme and all, obviously will depend upon the facts of each case. What are the assets, what are the liabilities, what are the tax benefits which a particular resolution applicant is going to get, and so on. So those things are going to be subjective. They will differ from case to case. So we cannot have actually a generalized standard for that. So if anybody has any things to add, I think I have completed my part of the case laws on whatever I had compiled here. If anybody wants to add anything, we can discuss that, or over to the organizers then.
Anaka, I think
Yeah.
Section 230 is misused to delay the IBC. This is what is it so?
So I delay IBC as in case of liquidation process, you're saying?
Yes.
Yes, it could be, because there's like we saw those couple of cases where they kept on saying that we are coming up with a scheme, don't sell the assets, don't sell the assets, and 2 years elapsed in that. So I think this definitely can be misused.
Despite the fact that Section 238 provides an overriding impact.
Yeah, so 238 overriding impact would be with reference to whether the NCLT has the powers to consider that at what stage and so on. The delay is not on the counts that whether to approach under 230 of Companies Act or to approach under Regulation 2B of the IBC. So that is very clear now that in case there is a scheme of arrangement that needs to go through an application by the liquidator under Regulation 2B. So in that sense, there is no conflict between Companies Act and 230 and IBC in that sense.
Why do an NCLAT or NCLT entertain such petitions when there is an overriding clause in the IBC?
So I don't think the applications which are filed are deciding the question whether to consider the scheme under 230 or under the IBC. I think those cases are not there. The cases are how much time to be given. Now that 90 days time frame has also come in, so which will be even more beneficial in completing the process much earlier. And that 90 days, and also now with that new amendment which came in, that within 30 days we need to file the scheme if there is something. So I think that will go a long way in curbing this delay dialing tactics.
Okay.
Anyone else wants to add anything? Otherwise, ma'am, we can conclude.
Participant, do you have any questions? Then you can ask. I think there are no questions.
There are no questions, ma'am. I'll be sharing this case law note with you. I'm requesting you to please share it with the participants.
Sure, ma'am. I will share it with the participants.
Thank you.
So thank you very much, ma'am, on behalf of all the participants and team ICSA IIT for taking out time and addressing session on the topic, understanding corporate restructuring under IBC and making the session insightful.
Thank you,
Now
ma'am.
I
Thank you
request
for the
ma'am to
opportunity.
please share a material with us.
I'll do that, ma'am. Thank you very much. Thank you. And thanks to the participants for a patient hearing.
Thank you.
Thank you.
Now the series is completed. The CP Miller will be circulated by tomorrow morning.
Okay.